Hello, viewers. You're welcome to the Edfields Podcast, your everyday law podcast. At the last episode, we discussed medical negligence and the law surrounding that area. We talked about what medical negligence is and what is not. And we talked about the duties of a medical practitioner. Today, we'll be discussing the rights of patients. We would also be looking at issues pertaining to consent and confidentiality. And I hope by the end of this episode, we would have answered a lot of questions bothering you on medical practitioners and how they perform their duties. Well, with me again, we still have Dr. Dadzi, a medical practitioner. We also have Angela. Angela, you're welcome.
Thank you, Jasmine.
And Albert, you're welcome.
It's an honor to be here.
Yeah, good. So, Angela, at the last episode, Dr. Dadzi told us
Yes.
that trainee medical practitioners would usually be supervised by a senior medical
Yes.
officer to guide them as to how to treat a patient.
Yes.
Now, that is for trainee. What about the hospital? Can the hospital, who is the employer of a medical doctor, be held liable for the acts of the medical practitioner, which is considered negligent?
Yes. Actually, the short answer is yes. And that's actually what happens in most cases. You'd rarely see a medical negligence case where they are suing the doctor by name.
Okay.
They sue the hospital because there's something we call vicarious liability in law.
Alright.
So vicarious liability is simply you being liable through someone else. So as you said, the hospital is the employer of the doctor. If the doctor is acting within his ordinary business in the hospital is to provide care under the duties Dr. Dadzi listed. So if the doctor or whatever medical practitioner it is acting in the ordinary course of his business, he's not acting outside what the hospital has employed him to do, then the patient can hold the hospital liable for vicarious liability. And most of the times, that's what happens. You rarely see a case where it is
the
a patient
individual
against the doctor himself or herself, unless maybe the court feels like...
Isn't it because we feel that the doctor may be a man of straw?
Yes.
And
So
and
go
the,
after
and
his
the hospital
employer who
has more money
to
Yes,
pay you.
yes.
because
Yes.
of what comes
Yes,
with it.
Exactly. And
okay.
so unless in specific circumstances where maybe the court feels like for this particular case, it will be usually for punitive purposes for the doctor to pay whatever compensation out of his own pocket. Usually is the hospital that is held liable.
Okay, great. Now, Albert, aside an action for medical negligence, can criminal proceedings be instituted against a medical practitioner who may have acted negligently?
So in our Criminal Offences Act, Act 29, we provide for negligently causing harm. Now, this is where it gets a little dicey. Section 72 is sort of like a broad provision, negligently causing harm. It categorizes negligently causing harm as a misdemeanor. For those of you who may not know how these things work, a misdemeanor is the least stage of seriousness that we attach to crimes.
Okay.
If you go to the section 73, there it categorizes different types of negligently causing harm.
Okay.
So, for instance, if you are in charge of a dangerous machine, a train, a car, you have a duty of care to whoever is with you in the vehicle and to other road users. So, if you do something wrong and harm results in what you did, you've breached this provision.
Yes.
And then a part of it talks specifically about individuals who are under a duty to provide medical or surgical treatments to people.
Okay.
the issue here again is that it also categorizes this as a misdemeanor. Now, I'm saying it's an issue because there might be instances where the harm that a person suffered is pretty serious. And also, one might ask, what of situations where it results in death?
Yes, that was going to be my
The
my
person.
next follow-up question. Yes.
So, yes, criminal action can be brought against any healthcare professional who is held to have breached or failed in his duty.
Which may have led to the death
Yes,
of a
yes.
patient.
Yes.
Yeah.
So
In that instance, I would think it's manslaughter, isn't it?
so to add to what Albert said, you see, the negligence can result. Usually, when we think of harm, we think of death, but that's like the extreme
That is
case.
the extreme
Yes.
case.
So there can actually be instances where medical negligence would be a misdemeanor, but in the situation where he's saying it leads to death, then that there's a whole new standard. Our viewers should remember in part 1 we talked about the civil standard of care being ordinary man in the doctor's skill in the same circumstance. That's for civil actions. If you want to bring criminal actions for medical negligence, the standard is also different, and that's wanton disregard for human life. That's where it leads to death. So in that case, you cannot come under the provision Albert mentioned to say that, oh, the law says that is a misdemeanor, where it leads to death.
Okay.
And you can prove that the action that led to the death was a wanton. Another word for wanton is reckless. It's like you can't possibly think of what would push that person to do that. It's so clear, it's so blatant that you don't care if the person dies or not.
All right.
That is wanton disregard for human life. So for the criminal aspect, as he said, it's a bit dicey. Depending on what harm was suffered, it could be a different degree of punishment attached to it. But once it leads to death, then there's that standard of wanton or reckless disregard for human life before you can succeed in criminal proceedings.
Okay, great. Angela, I still, maybe I should find out from you. I don't know if you've been to the hospital, and if you've
Yes,
not,
but
we thank
hopefully
God. We
not
thank
many
God for
times.
that. But I'm sure you know your rights and what kind of rights you feel you are entitled to when you visit a medical facility and you're receiving medical treatment. Maybe you can just outline a few for us.
To answer your question, yes, I have been, but
okay.
I will not be going back for a long time.
I would say amen to that.
Amen.
Yes, so they are broad. There's a lot of them. There are several regulating factors, but there are a few I want to hammer on personally to me.
Okay.
This first one is very, very important to me. Every patient has the right to full information of their condition.
Yes.
Yes. And doctor, it's not because he's here, but actually, I would recommend Dr. Dazi on that.
Oh, wow. He tells you everything, eh?
Yes. I've been to his place. Usually, what happens is, I don't know if it's an underestimation, but they just tell you what is wrong generally.
You mean the medical practitioners just tell you what is wrong
with you and take this medicine, do this. But maybe there are certain factors influencing what is wrong with me. They don't really go in depth unless you ask questions. Sometimes when you ask, it's taken as if, you will not understand. This is too technical. At least that's my experience.
Yes, some are not happy when they see you are asking too many questions.
Yes, there are some who will not volunteer the information without you asking. But I have the right to know the full information of my condition, whatever brought me there. Yes, whatever.
No matter how bad it is.
Yes. And sometimes they look at you, yeah, kwala. Means you see, there's actually yes, there's actually a lot about this, but
so to add on to what Angela is saying, if you look at the cases that develop the law on medical negligence, not in Ghana, but in the UK, common law, the earliest case, the story was a man who was suffering from depression. This was in the 1950s. And at that time, one of the ways they were treating depression was electroshock therapy. Right now, if I mention it, I shudder. But back then it worked. And if you look at the case, it says that the treatment actually worked for the man. His depression was treated. But the issue is that when they were treating him with the electric shock, they didn't restrain him. And there were certain things that the doctor didn't do. So when they shocked him, because he was moving, he ended up breaking his leg.
Okay.
I think he broke it or he dislocated it. In that instance, when the doctor was brought to the court, the doctor made the argument that this is a person who is a layman. He doesn't know the details about what the treatment entails and the risks associated with the treatment. And also, there are instances where, as a doctor, you would tell a patient possible side effects of the treatment he's going to undergo. And because of how the patient perceives the side effects to be serious, the patient doesn't want to undergo.
So
the
that is why they
treatment
keep information to
So
themselves.
the courts have looked at these instances too. The courts have looked at these instances too. Now, fast forward to the 80s, another landmark case. There's a person who is a woman, she's pregnant, but she works in a field that is associated to the medical field, you see. So you would assume that she isn't a layperson stricto sensu. Do you get it? She was going to deliver, and she would have liked to undergo cesarean section.
Okay.
But the doctors felt it was unnecessary. Whilst delivering, her child's head got stuck through the birth canal.
Okay.
The child suffered from lack of oxygen to the brain.
Okay.
Doc, correct me if I'm wrong. I think it's hypoxia. And the child suffered mental...
Cerebral palsy is what
Yes.
it's called.
In that instance, the woman sought to argue that I am somebody who will be able to make what we call an informed decision about whether or not I'll give consent to a medical procedure. So in that instance, it behoves on the healthcare professional to actually inform the patient of the associated risks. Nowadays, what happens is doctors apply a broad brush, full disclosure.
Some doctors give full disclosure.
Like Angela is saying, it makes you, the patient, also feel better.
Okay, good for that. Using the cases to explain further.
Yes.
Angela, I don't know if there are any other
Yes,
rights.
so aside the right to full disclosure of your condition, as he said, there's also the right to know the associated risks, the treatment they intend to take, associated risks with each treatment.
That is what Albert had mentioned earlier as well.
There's also the right to consent to partake in that treatment.
Okay.
So just because they have informed you of the treatment does not mean they can go ahead with it. You have to give them your consent. I think Doc mentioned that when he mentioned their duties.
Yes.
Yes. There's also the issue of confidentiality.
Yeah.
We hear this a lot. Doctor-patient confidentiality. Yes. So there's actually a lot of them. I'd like to hammer on these four for now.
Good. Dr. Dazi, where a patient is not in the right frame of mind to give consent to a particular medical procedure, what happens?
Can you? I'd like you to elaborate a little further.
Okay.
Because when you say right frame of mind, right state of mind, are we just looking at people who may not have the perhaps a cognitive ability to take a decision?
One, yes.
Or minors whose parents may be taking a
Two,
decision?
yes. So you are looking at
I think generally.
Generally,
yes.
Generally. So
yes.
basically what you're asking is, what if I need to take a decision that will save the person's life,
Yes.
but the person is disputing
Unable.
the decision for different reasons? Is that what you mean?
I would like to think it's where the person is unable
to give.
to
Okay.
give consent
So looking at the
one reason
cognitive.
or
So this is
And the
different
minor.
from someone who...
is refusing
is
to
One who is
refusing.
refusing, yes.
Okay, all right.
You can even add that because definitely I would
What's
want
that?
some
Right.
information on that too. So
Okay.
you could
So
cover
then
that as
so
well.
Right.
Yeah.
So there are a number of possibilities in this
Yes.
regard. So someone who is not in the right state of mind, let's assume somebody that may have some type of a mental illness.
Yes.
Right. The person came with a family, right? And a lot of times very complex because there should be some evidence that some member of the family has the deciding making authority regarding the person's health. Oftentimes, there's no
nobody.
documentation like that. We usually go with who presented with the person, either the wife or the parents, and then that's how we usually practically go about it. But what I believe is the right thing to do is usually to have an actual, written power of attorney. I have questions about this myself because I think that we're all learning in the medical field. And so I would say that the right thing to do is to have some document that says that this person is the one to take a decision. Because sometimes what happens, especially in Ghana...
It makes it clear.
Yes.
It makes it very easy.
What happens in Ghana and in Africa, because we have a very... it's sort of like a family-based, communal kind of thing.
Yes.
Someone is on the hospital bed. We need to take a decision. And now the family is going to meet to decide, what should be done.
And you're now going to draft a power of attorney, get the person to sign, and
let's say the
Precious
person.
time
Let's
is being
say the person
wasted.
has
Go
a
and
tumor,
get it sworn.
right? Let's say the person has a tumor, and we need to do a surgery to take out the tumor. And we've explained to the person that, look, these are the challenges with the surgery. Let's assume that we tell the person it's a 50-50 thing, right? The person could pass away on the table, there are a number of complications, but it could also be successful. Usually in a setting like that, let's say the person is married, right? But because of the tumor, let's say the person is unconscious, the person is on a respirator, something, right? And we need to speak to somebody. We would usually speak to the wife.
If
Right.
the person is
If the
married.
person is not able to, we are not able to communicate with the person. If the person is married, we usually speak to the wife. If the person is unmarried and even the person is an adult, we would usually speak to the caregiver, that's the parents or someone. But I know very well that practically we should have a document that says that this is the person to go to, a power of attorney, right? In that regard.
Doc, on that, I have a question.
Yeah.
So, say someone who has come in with a tumor, she has saying, and is unconscious. Say the person walked in, he was not brought with anyone, and gets unconscious while you get the question. Yes.
Yeah.
So he wasn't presented by anyone else. So whom do you ask for? And do we not fill out forms that state the next of kin when you are?
so if
Yes.
the person
As a-
the person is a
yes.
patient of that facility,
Yes.
I'm sure they
Yes.
would have the records.
Yes, the
already.
records are there. We ask who's the next of kin, and we go to the person. Usually, it's like I said, it's the caregiver or the wife. So there's a documented next of kin that we have to go to. That makes it easier. That in that case, you may not need an actual
Power of attorney.
power of attorney.
Attorney.
You know who the next of kin is. But I'm talking about in practical terms
Who
in
just
our
walked
settings,
in
right? Somebody who
without
just walked in without
documentation.
someone,
Okay.
or even somebody who's pointed out that this is these ones are not. We wouldn't say they are legal issues. They are more social kind of issues. And I'm just bringing this up for discussion. So someone is married, right? The person needs to the person is the documented next of kin. Let's take, for example, let me make it a little complex. When the patient came in, the patient was unconscious. Now, the person who brought the patient in is the one who fills out the form for the patient
Yeah.
and states themselves
As
as the next of kin.
Okay.
Do you get my point?
Yes.
And it
So
could
now-
it could have been someone who was just walking by.
Exactly. Or
And
let's
so-
even assume that is the person's wife, right? Or the person's husband. And we need to take a decision on this person. Now, even though the spouse is there, the family has also come. The parents, the brothers, the sisters, the aunties, they are saying he's also a relative. The documented next of kin who filled out the form when the person was unconscious says, I believe we should do this surgery. The family says, I don't think we should do the surgery. Now, in a way, our hands are tied as doctors. I'm just giving you
Some
the
of the
spectrum of
practicalities,
how these things get complex
So how do you
sometimes.
handle it? Because it seems very
And see,
So-
it makes your work more difficult.
Very.
Yes.
And so I'll give you I don't know whether I should share this. I'll give you a challenge we had at some point. So we had a patient. This was my patient. I heard this from a colleague, right? So a lady comes in and we explain to the spouse and herself that she's going to deliver. We've done everything possible. The best decision now is to do a cesarean section. This is what to save the mother and the child's life. And the husband says, who is the documented next of kin, says, no, we don't believe in cesarean sections in our family. Right. Our job now,
No,
really,
no.
as
this
a,
is,
I-
this
I-
is a situation where I believe that the man shouldn't see.
so you see, the wife is also agreeing with the husband because she
Oh, she's
believes that,
agreeing.
this is the husband.
that is
Let's
not-
put all
Put all those things aside.
religious and then those beliefs, cultural beliefs aside.
Hey.
Right now, in the next 6 hours, we need to take a decision. Let's say it's in the night, right? When you watch the shows, the medical shows on TV, so the doctor went with the head of the facility to their lawyer called the judge. Look, we are on night duty. The medical director is probably not on duty and not reachable. We need to take a decision. This is where real life medicine comes in because you have to find a way to convince them that this is the decision that needs to be made. As a lawyer, do you think we have the right to override their decision
And
in
that's
that
the thing.
circumstance?
That's
What
the
do you
thing.
think?
There are actually
Legally.
cases where I haven't seen any Ghanaian cases yet. I don't know about Angela, Jasmine. But there are American cases where doctors overrode a patient's decision to save the patient's life.
And they guess you.
The patients are now suing the doctor.
So a typical example is what we call a DNR.
Yes.
Do not resuscitate. And, before we started the show, we were talking. I just had a picture of a case where I was just about to resuscitate, and then my colleague held me,
They held you.
DNR. And I was a trainee. I was a house officer then. Like, what do you mean DNR? The guy's about to die. And telling me DNR. I said, well, do not resuscitate.
Yes.
So these are the complexities. I've not answered the question because it's a difficult question. And our jobs really as doctors, how we're trained is find a way to get the decision. Because if I am in training and I have a case like this, I have to report to my boss. Usually what my boss will tell me is that find a way to get a decision. Of course, not find a way to do the case, but find a way to get the
Convince
decision.
them to allow you to.
Yes. Yes.
And on the issue of consent, I think it will be important to put it out there that not all consent is viable
Okay.
or is valid.
Okay.
Because
I see.
when you ask Doc, he asked whether the person is a minor, the person has some mental. Yes, exactly. Because if the person is a minor and they tell you to go ahead, you cannot act on that consent. Legally, they don't have
The capacity.
the
to
mental
tell
capacity. They are not recognized to be able to think for themselves to make that decision.
Okay.
If the person has some cognitive disability, and emphasis on cognitive, because I think usually the blanket statement is persons with disability, but then you have to check what type of disability. Is it the kind that is affecting their mind, the kind that is affecting their ability to make decisions?
Okay.
You cannot say because this person is, excuse me to say, physically challenged, then he's a disabled person, so he cannot give consent. His disability is not affecting his ability to consent to whatever procedure is being done. But say a mad person, for want of a better word, has come to you that I want to have a C-section. He has consented technically, but then he's not recognized to have that capability to make that consent. Or a child like 12 years old, 11 years old. You always have to find the guardian of that person. Where it's a child, they would have maybe a parent or someone. Yes, you have to find the guardian of whoever is giving the consent, where it is obvious that they do not have the capability.
Angela,
to
let
make
me
the
ask you
consent.
this. So let's say the person is not a minor.
Yeah.
The person has shown evidence that they are of sound cognitive ability. They are an adult. Let's take the case that you brought up about the person who had some background in the medical space and then says, I think that this should be done. But from a medical standpoint, from a clinical standpoint, you know very well that I always tell when we have meetings in my clinic, for example, the administrative departments always want to say, the customer is always right. And I always tell them, usually in the medical field, the patient cannot always be right.
Yes.
Because if the patient is always right, a lot of patients will die. You know, because if you come and tell me that this drug is what you feel I should give you, because this is what you feel that you have,
That may not solve
that
the
may
problem.
not solve the problem. So there are also cases of people who feel that, I think a cesarean section, I'm just using that as an example because patient choice nowadays is also a factor when it comes to mode of delivery. But I'm just using the CS as an example and says, I believe that I need a CS. And there's no exact clinical indication for the CS, assuming patient choice was not a factor. Doing a CS might be dangerous to the person. And in that case, if I do the CS and something happens, trust me, as a peer, when we look at it from a peer review standpoint, my colleagues are not going to take my side in the sense, they'll tell you, look, you are not legally responsible, but you knew that you shouldn't have done this.
It's like, who are you to take that decision for the person?
Well, what do you think?
I think it falls back to your situation of convincing them to do it.
Yeah.
But then if you are not able to convince them legally, you can't force them.
Yeah.
So then and it shouldn't, I don't think it's something that should be on your conscience either, because you genuinely did everything in your power.
But there's something I know the medical facilities do now. They would, when you don't accept the doctor's recommendation and the doctor is about to let you go and deal with your situation the way you want to, after giving you all the advice, they let you sign something.
waiver.
Yes.
You sign something saying that you've been advised.
Against medical advice.
Yes.
Discharge against medical advice.
Yes, they call it a discharge, yes. So
We should clarify that for the viewers.
Yeah.
Some facilities use that as a basis to not treat people when they return. I think it's a terrible thing.
Okay.
I think if somebody decides that they will not go with your medical advice, it's not the basis to say that if the person changes their mind and returns to
Turns
you,
back, then you
they're
say-
not going to treat them.
Yeah.
I am sure it's not done nowadays. In the past, it used to be used as sort of a bargaining chip to get the person to change their mind. You know,
Okay.
so the person says, I mean, I know this is the right thing, I'm still not going to do it. And then they sort of use that, if you come back, we will
And
not
you come in the west
I
states
think
than
that
you were.
it's not a good bargaining chip. If the person says, I don't agree with you, and the person changes their mind, I now agree with you, just let the person sign again and go ahead and treat the person. You know.
I think the crazy thing here, though, is that both sides can be justified.
Yeah.
If you really think about it.
They can
Both
both
sides
can be justified.
Yes,
Well,
that is why
until
I
the
don't
situation,
think,
you are met with the situation, then
Yes.
you know how to.
But can I put this question
deal
out
with
there
it? Yeah.
before we might end on this? We've talked about people that we've talked about decision making in medicine, and I thought that somebody would bring up the religious bits, especially when it comes to some cases transfusions and the
Yes.
like. Usually is looked at from the lens of the patient,
Okay.
right? But not many people look at it from the lens of the doctor. So I'll give you a scenario. Let's say a patient has a right to decide that I do not want to be resuscitated at the point of death. That is my religious belief. They're supposed to abide by it, right? Or I do not accept blood transfusions, right? And this person is of sound mind, is of age, has given legitimate reasons that they believe that they should not be transfused. You said you can't force them. It shouldn't be on your conscience, right? That's fair. Now let's look at it from the doctor's standpoint. Let's say a doctor believes that my religious beliefs do not allow me to do terminations of pregnancies, for
Okay.
example.
Okay.
Right. Does the doctor have the right to say, in some cases, that because of my religious beliefs, I cannot do this, hence I'll refer you to another doctor legally? What do you think?
Yes,
I think
that's
allowed.
fine. The
You
doctor
are
can
not,
do that.
Yes, you are not refusing the person care. It's just the mode of the agent giving the care has changed.
Yeah.
You are not refusing to. You can still take what the person's record keeping. You can still take the record, everything, and then refer him to someone else. I don't think that breaches.
Doesn't
your
that take away
duty.
the liability then from you, the doctor who is recommending for another doctor, and whatever happens with the other doctor?
Yes.
Can
basically.
I be in trouble for referring a patient to another doctor, and something bad happens?
Oh, in terms of liability,
Yeah.
the liability is transferred to
the-
the other
the
doctor
other
because
doctor.
they are the ones actually providing you
That
with
service
the
at
service,
at
yes.
that time.
But for Dr. Dazi's question, I do not think the doctor can be held liable for a breach of duty because he refused to terminate your
Okay.
pregnancy. He
All
did
right.
not refuse you medical attention. He just changed who is giving you the attention. He didn't say, oh, no, no. And in your case, you referred the person to someone else.
Yeah.
Yes, so he has still fulfilled whatever he
Right.
had with you and has transferred it to someone else, transferring the liability and everything that comes with it to someone else.
I think
Captain.
it's like a lawyer who says,
Yeah.
I would never do divorce matters. It's
Yes,
just a matter
you
of
can't,
belief.
you can't,
Yeah.
you
Yes,
can't
he would do every
sue
other
the
case, but when it
exactly.
comes to matrimonial cases,
Yeah.
the doctor would, the lawyer would refrain from doing that.
Jasmine, before you came, I was going to say that everybody's rights end where another person's
Person's
rights begin.
begin.
So,
So we must respect that, isn't it?
And
All
freedom
right.
of religion is a
It's a
constitutionally guaranteed
Guaranteed.
freedom. So
Okay.
he's free to believe in whatever he believes in and act accordingly.
Great, great. One of the duties Dr. Dazi gave at the last episode was the duty on medical practitioners to be confidential in their dealings with their patients. What would be the situation if medical records of a patient is leaked out to the public?
that's actually serious. And it constitutes a breach of the relationship between the doctor and the patient. There are certain professions where, as a result of the sensitive nature of the information going around, the professionals have a duty to take particular care of the information of their clients. Medicine is one of those professions. So in that instance, the doctor has breached the confidentiality duty placed upon him.
Okay.
And the patient should be able to sue to recover damages for that
Wow.
breach.
Yes. To add to what Albert, that's the general rule
Mm.
that yes, there's confidentiality, but there's an important exception we shouldn't overlook, where it is in the interest of the public to make those records known.
Okay.
Then it will not be a breach. So let's say COVID, for instance, it's a global pandemic. Say before it became public, before it became widely known, I went to Dr. Dazi, he treated me, he realized I have COVID. It has not become public yet, but he knows it's a potential pandemic. If it's not made known, it's going to, I can't just tell him, oh, keep this between us, doctor-patient confidentiality, I'm going back home and go and mingle with my family. No. For legally, he's allowed to publish that information to the authorities that this person came to my hospital, this is what I found out by the WHO or whatever standards, this is a potential pandemic.
Did you say the WHO?
World Health Organization.
Oh, that's what you're calling them now.
Yes, so the World Health Organization or whatever international standard, I believe this is a potential pandemic. In the interest of the public and for public safety, he can breach.
Okay.
It's not a breach. He can
Pass on
share
that
information, and it will not
information
amount to a breach of his duty.
Doc,
Okay.
do we have something like that when it comes to HIV and AIDS?
I think this question has been asked you before in a different.
Yeah.
Yeah.
I remember.
So maybe you should
Yeah.
answer.
I remember. It's another complicated issue because, like she's saying, the information, when she gave the COVID example, for example, we're not giving the information to the public as just information that's out there. The information is being used
To input
for the
to use.
yes,
For
for the
the
purpose of
benefit
protection
of the public.
for the benefit of the public. For retroviral infections or HIV, like you said, the information might not, because we may not consider it as a pandemic at this point.
Okay.
The information is not to be put out there for everybody to know, so that you know that
You'll be
you know,
victimized.
this person
My neighbor has
is
it.
HIV. So
you
don't
you are
the challenge now becomes, and I think that's what happened in our previous, that's what we talked about in our previous discussion, is that let's say somebody knows that they are HIV positive, and the person decides, for whatever, whether on purpose or not on purpose. That, I have multiple sexual partners, and we are having unprotected sexual activity. It's not a pandemic.
That's the difference.
It's not a pandemic.
You have HIV.
Now I put the question back to you as a lawyer: has the person committed a crime by saying, "Well, it was not forceful sexual activity. It was consensual. We both decided that we are doing." You also may have decided, either male or female, to not use protection.
The fortunate, or should I say unfortunate thing, is that a situation exactly like this has happened. And in that instance, the court said consent ends where you fail to disclose your HIV status to your sexual partners. So having sex with someone, the person consented to have sex with you, but the person didn't consent
to
attract
at all. So yes, the consent ends where you infected the person.
Right.
Yeah.
I see.
Right. So in this case, for example, let's assume I have a patient who might be HIV positive, and let's say the person's unconscious, right? It is therefore not wrong for me to tell the nurse who is going to administer
Careful.
medication
To be careful and
that
protect
be careful.
herself.
Yes.
Usually, practically, what we would do is indicate on the folder in some coded language that we have as practitioners that this person may be HIV positive.
Okay.
We will not write,
Don't write
HIV positive
exactly
plainly. There are terms that we use that practitioners know that, okay, I need to
doctors'
be
net
careful.
terms.
You also have your terms. You've used a few of them in this discussion. So there are ways to communicate that. But I don't think it would be wrong legally to
No.
let someone know that, be careful, because we have ways of doing it. For example, something that I would tell someone, remember to double glove.
Double.
Yes,
The
double
person
glove.
just knows-
It just knows what that means.
Maybe I'm
okay.
disclosing the
Yes,
cover.
yeah.
But the person
Yeah.
just knows that,
That-
okay, I just need to be careful. I've not told you what the
What?
condition
Just
is.
say
Yes.
But you
protect
just
yourself.
know that, okay, I have to be a little careful.
Okay.
And
Careful.
also that disclosure is necessary for the person's performance of his or her duties. So that is
Okay.
not a breach.
Angela, quickly, we are running out of time. What remedies are available to a patient who feels a doctor was negligent in treating him or her?
So the most common one is damages. Damages is simply compensation, and although you cannot put an amount on human life for whatever loss was suffered, the courts try to give you what they think is fair in the circumstance. They look at the circumstance of the case, and as Albert said, negligence cases, medical negligence cases specifically, are usually on a case-by-case basis. So on this particular case, what is a fair amount of compensation? That's what we call damages. And in some circumstances, the courts also give punitive as a way of punishing the medical doctor. Remember, we said usually they sue the hospital.
Yeah.
So the damages, more often than not, is the hospital that pays.
Okay.
But where the court feels like this particular negligence was so bad that I want
Grievous.
the
It was
doctor to
grievous.
feel
Feel the pain,
something so he
yes.
doesn't do this again. They can give punitive damages against the doctor himself or herself, or they can suspend their license for a period of time, or sometimes revoke
indefinitely
their license
revoke the
altogether.
license.
Yes.
But and then it would mean that the doctor was joined to the suit as maybe a second or third
Yeah,
defendant.
Yes.
that's always the
Yes.
case.
Yes.
Yeah.
So
Okay.
yes.
Great.
So there's damages, there's the revocation or suspension of the license, and we mentioned that sometimes it can lead to criminal proceedings.
okay.
Where it leads to criminal proceedings, there can be criminal
So fines
consequences.
and
Fines, jail.
and jail term.
Yes.
Okay. All right. Well, viewers, I think it's been a beautiful discussion. I believe that now you know everything you need to know about your rights as a patient and how to identify whether a medical practitioner has been negligent in performing his duties. I also want to say that if you want further information on this, you can send a question or a comment to us on any of our social media handles, and we'll be happy to assist you. So thank you very much for joining us. I would encourage you to subscribe to our YouTube channel, and hopefully we would see in another episode. Have a good afternoon.